The phone is face down on the passenger seat. The officer leans toward the window, torch in hand, easy as a neighbor. He says the words like a request. I am going to need you to unlock that for me. And here is what almost nobody in this country has been told clearly. There is no simple rule in Canada that makes a passcode automatically safer than your face, the way there is in American constitutional law. That split is built on the Fifth Amendment, and it does not exist here in the same form. What does exist in Canada is a legal framework with 4 distinct doors that can compel a phone to open. And standing at that curb, in most ordinary encounters, none of those doors will have been opened yet. This video gives you the words that keep you from handing over access before anyone has properly earned the right to demand it. Because the most expensive mistake a Canadian makes in that moment is not refusing something they were required to give. It is volunteering something nobody had yet earned the legal authority to take. Start with what you actually owe, because none of that part is optional, and pretending it is creates worse problems than the ones you are trying to avoid. If a police officer lawfully stops you and has reasonable grounds to suspect you have been involved in an offense, you are required in most provinces to provide your name and address. In Ontario, Section 33 of the Highway Traffic Act requires a driver to produce their license, insurance, and registration on demand. You stop when directed to stop, you follow lawful directions, and if a device is lawfully seized under a warrant or another valid legal authority, you hand it over. You do not hide it, you do not wipe it, you do not delete a message from it once you know or reasonably suspect it may be seized. Because interfering with or concealing evidence that may be required in a proceeding carries serious consequences under Section 139 of the Criminal Code. That is the one mistake that turns a difficult night into a considerably longer one. Comply fully with your hands visible. That is the baseline. Now the part most Canadians have never been told clearly. Nothing in that list is your passcode. There is no general power in Canada for an officer standing at your window to compel you to unlock your phone simply because they want to look inside it. Not on the roadside, not as a routine request. Not by asking in a friendly way that sounds like cooperation is expected. What compels a phone to open in Canada is a specific legal instrument issued by a judicial officer. Until that instrument exists, a request is still a request, and declining a request is not an offense. There are 4 legal doors in Canada that can change that. 4, and only 4 in the sense relevant to the ordinary person in an ordinary encounter. Each one is a compulsion instrument, something made by or through a judicial officer, not handed through a car window on the street. Door 1 is the general production order under Section 487.012 of the Criminal Code. It requires a person to produce a document or data to a peace officer. It must be made by a justice or judge, and it must relate to an investigation of a specific offense. Door 2 is the order to assist under Section 487.02 of the Criminal Code. When a warrant or production order has been issued, a judge can order a specified person to provide assistance reasonably required to give effect to it. This is the provision that gets closest to compelling you to unlock a specific device. Door 3 is a search warrant issued under Section 487, authorizing officers to search and seize things. By itself, a search warrant authorizes the seizure of the phone. It does not automatically compel you to provide the passcode to open it. which is why door 2 frequently follows it. Door 4 is the more targeted computer search regime under sections 487.01 and related provisions, allowing for warrants in relation to computer systems with assistance orders attached. Other provisions exist for national security matters, organized crime investigations, and border contexts. This video is speaking to the ordinary person in an ordinary encounter, not to the exceptional cases at the edges of the framework. If you are in one of those exceptional situations, you need a lawyer immediately, and this is not the video for your circumstances. Now, let me tell you why the words matter and what they are actually doing. Most Canadians, when a uniformed officer asks them to unlock a phone, do what they have been taught their whole lives to do. They cooperate. They think cooperation signals innocence. They think the person who hands over the phone quickly is the person who gets to go home quickly. That instinct is not foolish. It is the way most of us have been raised to behave at every counter, every front desk, every window where someone in a position of authority makes a request. The instinct has served you well everywhere else. It is the most expensive habit you can carry into a police stop involving your phone, because the machinery on the other side of that window is built to receive exactly what you were built to give. So before we go further, let us name the thing half of you are already thinking. Will refusing make me look guilty? Will the officer write it down? Will some magistrate hear that I would not hand over my phone and assume the worst? Answer it straight. Guilt is evidence, not a tone of voice. The right to be silent about the contents of your mind and the right to decline to assist in accessing your own private communications are not admissions of guilt. They are constitutional rights that exist precisely because an accusatorial system requires the state to prove its case, not because it requires you to build it. Under the Canadian Charter of Rights and Freedoms, Section 7 protects the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. The common law principle against self-incrimination, which the Supreme Court of Canada has affirmed as a principle of fundamental justice under Section 7, means that you are not required to be an instrument of your own prosecution. Declining to unlock a phone before you are lawfully compelled to do so is not an exercise of guilt. It is an exercise of a right that exists because the law recognizes something the request at the window does not. The Supreme Court of Canada addressed the privacy expectations that apply to smartphones directly in RV Fearon 2014 and in RV Maraca 2017 and RV Jones 2017. In Maraca, Chief Justice McLaughlin wrote that text messages and other communications stored on a smartphone attract a reasonable expectation of privacy, not only on the part of the sender, but potentially also on the part of the recipient. In RV Spencer 2014, the court confirmed that Canadians have a meaningful and constitutionally recognized expectation of informational privacy in their digital lives. The phone is not a wallet. It is not a glove box. It is the accumulated private record of your communications, your location, your associations, your searches, your financial transactions, your health information, your relationships, all of it, years of it. The legal framework around accessing that record exists precisely because courts have recognized that it is categorically different from searching a person's pockets. None of this makes a lawful order go away. It makes clear what an order actually is and why the distinction between a request and an order matters as much as it does. Here are the words, 3 short pieces. Say them out loud once before you need them so they belong to you rather than to a script you are trying to remember. I do not consent to unlocking this phone. I will comply with any lawful direction or order. Is there a court order requiring me to do this? Now let me break down what each piece is doing. I do not consent to unlocking this phone. This withholds the one thing no one can extract without you. A phone locked with a passcode is locked behind something that exists only inside your mind. Under Canadian law, the compelled production of information from your mind raises significant questions under Section 7 of the Charter and the principle against self-incrimination. It does not resolve those questions automatically in your favor, particularly once a valid order has been made. But before an order has been made, you are not declining to comply with an order. You are declining to volunteer. Those are legally different acts. Only one of them carries any consequence. I will comply with any lawful direction or order. This sentence kills the word uncooperative before it is written into a report. You are not resisting. You are not hostile. You are distinguishing between what you are required to do and what you are being asked to do. That distinction is not defiance. It is the Charter doing what the Charter was built to do. This sentence makes clear that you understand the difference and that you are not claiming the right to refuse everything. You are claiming the right to require the state to use the proper process. Is there a court order requiring me to do this? This makes the encounter declare itself. Is this a request or a requirement? Is there a judicial instrument in existence that changes what I owe? This is not a rhetorical challenge. It is a genuine question whose answer determines what comes next. If the answer is yes, and it is a valid order, the second sentence takes over. If the answer is no, then you have clarified the situation precisely and your position stands. Now watch them push, because they will. And there are two pushes you will see most often. Push one comes wrapped in convenience. If you have nothing to hide, just unlock it. It will take 2 seconds. Do not engage the framing. Do not explain yourself. The moment you start explaining, you are defending a position instead of holding one. You say the same 3 sentences in the same order, same tone. I do not consent to unlocking this phone. I will comply with any lawful direction or order. Is there a court order requiring me to do this? Push 2 comes wrapped in inevitability. We can always get an order anyway, so why make this harder than it needs to be? The phone stays face down. The answer stays the same. I do not consent to unlocking this phone. I will comply with any lawful direction or order. Is there a court order requiring me to do this? What someone could obtain eventually is not what they have obtained now. An order that has not been made is still an order that has not been made. Until it has, the answer does not change. If a valid order is actually produced, the second sentence takes over and you say 3 different things. Can I see that order in writing, please? If it is valid, I will comply exactly as required. I am not refusing. I am asking what has actually been made. At that point, you should be contacting a lawyer as quickly as the circumstances allow. Section 10B of the Charter gives every detained person the right to retain and instruct counsel without delay and to be informed of that right. That right applies here. Use it before you comply with any compulsion order, if at all possible, because the scope of what the order actually requires may be narrower than the way it is being described to you. Now, the face versus passcode question, because you have heard a version of it from somewhere, and it is worth addressing directly and honestly. In American law, the argument that a passcode is protected by the Fifth Amendment privilege against self-incrimination, while a biometric is not, has been debated in courts for years. That is American constitutional law. It does not apply in Canada. The Charter does not contain a provision that mirrors the Fifth Amendment in the same structural way. Section 11C of the Charter protects a person charged with an offense from being compelled to be a witness against themselves. Section 7 protects against the compelled production of testimony that would be self-incriminating as a principle of fundamental justice. But neither of these provisions has been interpreted by Canadian courts to create the clear biometric versus passcode split that exists in American jurisprudence. The assistance order regime in the criminal code, specifically section 487.02, is built around requiring a person to provide assistance, not around requiring a person to speak a specific thing. Placing a finger on a sensor is assistance. Turning a face toward a lens is assistance. Providing a passcode is also assistance. The statutory language does not carve out one type of access from another based on whether it requires speaking versus physical action. So why do I still recommend keeping your phone locked with a passcode and keeping it face down? Not for a legal reason that creates a guaranteed protection, for a practical reason that creates time and friction. A passcode exists only in your mind. To be produced, it must pass through your voluntary cooperation. Even under a compulsion order, the scope of what you are being required to say is a question your lawyer can examine. A face and a finger are attached to you, sitting right there in the same location as the device. Without any cooperation from you, an officer holding your phone and directing it at your face has done something. It may or may not be lawful. It may or may not produce a result, but it does not require the same legal step that compelling your mental knowledge requires. The biometric access method does not give you a stronger legal right. It gives you a shorter practical timeline. And on a night when no order has yet been obtained, longer is better. These cases are not remote legal abstractions. They are the framework within which every police request to unlock a phone in Canada operates. When an officer asks you to unlock your phone, they are asking for access to exactly the kind of information Canadian courts have recognized as deserving serious constitutional protection. The request does not carry with it the authority of the protection. The three sentences hold. Now, the part about what happens in the gap before any compulsion order has been obtained, because this is the window where most Canadians make the expensive mistake. And understanding why it is expensive is what makes the alternative feel worth the awkward moment at the window. An open phone in the hands of an officer with forensic extraction tools is not the screen you are looking at right now. Modern forensic tools can recover deleted messages, location history across months and years, application data that never appeared in your regular view of the device, call records, contact associations, browsing history, and metadata that tells a story about your movements and your communications that you yourself would struggle to reconstruct from memory. The request to unlock a phone is a request to open not a window, but a warehouse. Everything you have stored, sent, received, searched for, and been physically near for as long as you have owned that device. Not the one conversation you are worried about. All of them. Every version of you that has existed in the years since you bought it. That is what is sitting face down on the seat. And that is what the three sentences protect until the legal process provides a proper basis to access it. Now, there is one more context that changes the calculation entirely, and it sits completely outside the four doors. The airport, the border crossing, a Canadian Border Services Agency officer operating under the Customs Act is not working within the same framework as a provincial police officer on a public road. The legal basis for examining goods at a port of entry is different, the threshold is different, and the courts are still working through what the constitutional limits look like in that specific context. The Federal Court of Appeal decision in Canfield v. Canada from 2020 moved the law forward but did not resolve it. What it confirmed is that digital devices are not simply goods in the ordinary sense, that examining their contents engages Section 8 of the Charter, and that the appropriate standard for border device searches requires further development. The law is unsettled here. The same three sentences remain a useful starting point if a border officer asks you to unlock a device. But know that you are in a more contested legal space than on the public road, and that the outcome of any challenge is less predictable. If you travel internationally, and this is a concern for your specific circumstances, legal advice specific to the border context is worth getting before you next travel, not after. At a Canadian port of entry, Canada Border Services Agency officers operate under the Customs Act. Section 99 of the Customs Act authorizes CBSA officers to examine goods that are imported into Canada. Courts have considered whether digital devices constitute goods for the purposes of that examination power. In Canfield v. Canada Attorney General 2020, the Federal Court of Appeal found that the warrantless search of electronic devices at the border engages Section 8 of the Charter, and that the standard applied to border device searches must be developed through further legal proceedings. The law in this area is unsettled and evolving. What is clear is that the border context is legally distinct from an ordinary police encounter. The threshold for searches at a border crossing is different, and the presumption of privacy in your device competes with a different regulatory framework than applies to a routine traffic stop. If you are crossing a border and your device is requested for examination, the three-sentence script remains a useful starting point, but the situation is more complicated, and the legal advice you need is specific to that context. Know before you travel that this is an area where the law is in flux and where the answer is less clear than in the ordinary domestic police encounter. Let me address the people watching this who have already done it, who unlocked the phone once, last month, last year, at a gate or a traffic stop because it seemed easier than whatever the alternative looked like, and because the feeling in your chest when someone in uniform asks you a direct question is not a feeling most people have been trained to sit with. You have not given up anything permanent. There is no legal doctrine in Canada under which cooperating once creates an ongoing obligation to cooperate again. Unlocking a phone in one encounter does not waive a right you still hold in the next one. You can stop mid-conversation. You can say, actually, I would prefer not to continue with this without seeing a proper order. No apology is required. No explanation is owed. An order that has not been made is still an order that has not been made, regardless of what you did 5 minutes ago. You can turn it back. That is the whole point. Here is what happens if the device is seized. Ask for a property receipt before any officer walks away with it. In practice, this is documentation that the device was taken, by whom, and under what authority. Note the officer's name, badge number, and the detachment or unit. Write everything down as soon as the encounter ends. Sign it and date it. A note made in a parking lot at 10 at night beats a recollection 11 months later in any proceeding. Ask under what power the seizure was made. The answer tells you a great deal about what happens next. Under the criminal code, seized property is subject to rules about retention and return. Section 490 provides a framework under which seized items must be dealt with, including provisions for the court to order the return of property. If you believe a device was seized without lawful authority, that is an argument for a proceeding, not for the side of the road. Your lawyer can bring an application under Section 490 or can challenge the admission of anything found on the device under Section 242 of the Charter, which allows a court to exclude evidence obtained in a manner that violated the Charter, where admitting it would bring the administration of justice into disrepute. This is a discretionary remedy with factors that cut in both directions, but it is a real remedy that requires the court to consider the seriousness of the state conduct and the impact on the charter-protected interests of the accused. If you believe the conduct of the officer in the encounter was improper, the oversight bodies exist and they are accessible. In Ontario, complaints about provincial police can go to the Ontario Civilian Police Commission or the Special Investigations Unit for more serious matters. For RCMP, the Civilian Review and Complaints Commission is the relevant body. For municipal police services, the relevant provincial police oversight body has jurisdiction. A complaint creates a record where one did not exist. That record has value. I do not consent to unlocking this phone. I will comply with any lawful direction or order. Is there a court order requiring me to do this? Say them in your kitchen tonight. Say them once out loud so they belong to you rather than to a script you are trying to retrieve under pressure. Then put them in your phone notes. Title it "If I Am Stopped," because the night you need them, your brain will not write new material. The words that come out under pressure are the words that were already there. This is general legal information about your rights under the Charter and relevant Canadian legislation. It is not legal advice for your specific situation. Laws develop, cases add nuance, and your particular circumstances may raise considerations that this general discussion cannot address. If a device is seized, if you are detained, if charges follow, the conversation moves from this video to a lawyer who knows your facts. Legal aid is available in every province. A criminal defense lawyer is the right first call. Send this to the person in your family who hands over everything without thinking, because they believe that is what cooperation looks like. Because cooperation and capitulation are different things. And the law in this country was built to protect the difference. The torch clicks off, the window goes up, the radio is low, and the phone is exactly where it started. Face down on the seat beside you, opened by nobody but you.